Justice Jackson?
So I guess I'm kind of hung up on the posture in which we find ourselves looking at these issues. Justice Alito, I think, focused on this a little bit, when he says that the district court makes this initial determination. It turns out to be wrong. The remedy, I thought, was to appeal. And I guess, for me, the question is whether and under what circumstances the government keeps on doing the thing that the court has found unlawful while the litigation is proceeding to determine whether or not the government's activity violates the law. We're sort of in an interim posture. Many of your arguments, and I appreciate them, are kind of couched in, the state is going to need complete relief for their injury, and that's true definitely as a final matter. But here we are at the beginning of this litigation. No one has determined whether or not the government's conduct is actually unlawful. We have a district court, several district courts, and now courts of appeals that say it is, and so as an interim matter, we are saying the government has to stop doing it while we litigate the issue of the unlawfulness. To me, that kind of puts the whole thing in a different frame. It's sort of like, why isn't the question in this posture, in this circumstance, can the government or has the government shown that it is going to suffer some sort of harm from being made to completely stop this activity while we're litigating the lawfulness of the conduct? I don't understand. And then you say, yes, we're going to suffer harm. This is the balance of the equities that, part of the PI and the stay showing. But I just don't understand why that's not the focus here. And I don't know what and I apologize because I didn't get a chance to ask Mr. Sauer this, and maybe he can address this on his rebuttal. But, what problem is the government facing as a harm matter from being completely told it has to stop doing this while we, the court system, determine whether or not its conduct is lawful?
So we included this in our application. We do think this case is quite unique in that I do think it's hard for the government to show in this particular case that it needs to be able to act contrary to this court's settled precedent. That's obviously come up in a couple of questions today. It's something, if I realize the elephant in the room, I've often been asked to assume that the merits are put to the side, and I'm fine assuming that for those questions. But to your point, you're not wrong. It is quite striking, obviously, that it's not just that district courts are saying, this looks like it might be unlawful. They're saying Wong Kim Ark settled this exact issue 127 years ago. This court has reaffirmed it since. Over a century of executive practice is built on that, and Congress has codified that directly into law. So I do think it's a particularly unusual case for the government to be saying that it has been quite so harmed and needs this kind of relief. But at the end of the day, I'm happy to join issue on when relief may or may not be appropriate, and I just think we're clearly on the positive side.
But you're saying that at least in some circumstances, from your perspective, in order to even decide whether or not you are entitled to an interim complete injunction, the court's now going to have to peek at the merits while the merits are being litigated?
I think the court always has to peek at the merits in deciding whether the party itself should be getting relief from its harms, including complete relief as even the United States accepts. So those are all four of the winter factors. You have to figure out what the irreparable harm is that you're trying to deal with. You have to figure out if we have a sufficient merits showing in order to eliminate that irreparable harm. And depending on the strength of the merits showing, you're also looking at winter's factors 3 and 4. So this court has given 4 winter factors that I think are quite useful in most cases. I took my friends on the other side to be saying, well, beyond the winter factors, there's this bright line rule from Article 3 or the history of equity that just says it can never get to this point. I obviously disagree a bit with them on the reading of that history, but I just think it has no bearing on the case that the states bring to this court here.
Thank you.
Thank you, counsel.